Wilkester, you can take the link for BRS. So that we begin at around section 6 of the Companies Act. Mr. Chadwick, if you can, if you are able to open the Companies Act and present to us, so that we see the types of companies, then we see the various conditions for each type of company. So for example, why do we call it a private company limited? What are the restrictions for private limited? Then if you want to convert to a public, if you want to, and actually not even, it's not a must even we do the conversions now. You can just do each type of company as it is, then we shall see in the question papers on the various models of conversions. So Chadwick, I hope you're there with the Companies Act. We can begin. Then we shall also see the company's registry. There are those manuals and practice notes that are in the BRS. So we shall be referring to the Companies Act, Cap 486. We shall be referring to the Registration of Business Names Act, Cap 499 of the Laws of Kenya. We shall be referring to the Limited Liability Partnerships Act of number 42 of 2011. Then from there, we shall be having all the subsidiary legislations. We shall be having the forms, the forms that you make in any particular application. So
just a minute as I try to locate the act.
okay. As Chadwick is presenting, I wish to present.
Should I share my screen or like I just read it?
Yes, share the screen.
I hope you can see what I'm sharing.
Yes. So Chadwick is presenting the Companies Act. You can begin, Chadwick.
Okay, so part 2 of the companies and company information, types of companies. So first one, you have limited companies. So section 5 provides that for the purpose of this act, a company is a limited company if it's a company limited by shares or by guarantee. So section 6 provides for company limited by shares which states that a company is a company limited by shares if the liability of its members is limited by the company's articles to any amount unpaid on the shares held by the members. So, for example, let's say if you promised to invest a total of 1 million, and you have managed to put in 500,000, so the remaining 500,000 will be what the unpaid shares that you are holding as a member. And then section 6.2 provides that the liability of the members of an existing company is taken to be limited by the company's article to any amount unpaid on the shares held by the members if a condition of the memorandum of association of the company stating that the liability of the members is limited is regarded as provisions of articles by virtue of section 70. And then under section 7, company limited by guarantee. For the purpose of this act, a company is limited by guarantee if it does not have a share capital, the liability of its members is limited by the company's article to the amount that the members undertake by those articles to contribute to the asset of the company in the event of its liquidation, and its certification of incorporation states that it's a company limited by guarantee. So this is some of the distinguishing feature of the company limited by guarantee. It will be expressly stated. And then subsection 2 provides that subsection 1 does not prohibit a company limited by guarantee from having a share capital if it was formed and registered before the commencement of this section. So what does that mean? Subsection 1 does not prohibit a company limited by guarantee from having a share capital if it was formed and registered before the commencement of this section. So this is just clear that if, let's say, the company was limited, there's a share capital before this section came into force, then that company will still be active. The share capital will still be intact, even though the company now wants to be a company limited by guarantee. And then going to section 8, a limited company. So this is a company that, number one, has no limit on the liability of its members. And then its certificate of incorporation states that the liability of its members is unlimited. And then private company, this is a company that restricts members' right to transfer shares. It limits the number of its members to 50 and prohibit invitation to the public to subscribe to its shares or debenture of the company. Requires the consent of all members to add a new member. Section 1B provides that it's not a company limited by guarantee, and its certificate of incorporation states that it's a private company. So meaning a private company is not a company limited by guarantee. That's something that is outstanding. And then subsection 2, in subsection 1A2, members exclude a member who is an employee of the company and a person who was a member while being an employee of the company and who continues to be a member after ceasing to be such an employee. For the purpose of this section, 2 or more persons who hold shares in a company jointly are taken to be a single member. And then we have the public company under section 10. A company is a public company if its article allows its members the right to transfer their shares in the company. Its article do not prohibit invitation to the public to subscribe to the share or debentures of the company, and its certificate of incorporation states that it's a public company. Yeah, so subsection 11 is on the formation of a company. So it's provided that one or more person who wish to form a company may subscribe their name to the Memorandum of Association and comply with the requirement of Section 13 to 16 in respect of registration. A company formed for unlawful purpose may not be registered. Should I continue or like I stop there?
You can proceed to method of forming a company, then we can go straight to BRS.
Okay, let me just proceed. So, I've tackled the section 11, but let's see section 13, how one register a company. So, section 12 provides that a memorandum of association is a memorandum stating that the subscriber who wish to form a company under this act agree to become members of the company, and in the case of a company that is to have a share capital, to take at least one share each. A company may not be registered unless its memorandum of association is in the form prescribed by the regulations and authenticated by its subscriber. So the registration process, what are required are provided in section 13, which provides that you lodge with the registrar an application for registration of the company that complies with subsection 2 and 4, and then a memorandum of association, and except as provided by section 21, a copy proposed article of association. Then section 2 provides an application, subsection 2, an application for registration complies with this subsection if it states the proposed name of the company, the proposed location, whether the liability of its members is limited, and if so, whether it is to be limited by shares or by guarantee, or whether the company is to be a private or public company. If the application for registration of a company is submitted by an agent for the subscriber to the memorandum of association, the agent shall include in the application the name and address of the agent. Subsection 4, an application for registration complies with this subsection if it contains and is accompanied by, in case of a company that is to have a share capital, a statement of capital and initial shareholding in accordance with section 14. In the case of a company that is limited by guarantee, a statement of guarantee in accordance with section 15. A statement of the company's proposed office in accordance with section 16, and a statement of particulars in respect of each beneficial owner of the proposed company in accordance with section 16A of this act. So the article of association, it should be contained in a single document. It should be printed, divided into paragraph numbered consecutively, and be dated and be signed by each subscriber to the article. A subscriber's signature is required to be attested by a witness whose name, occupation, and postal address are required to be written and printed below. So there's the statement of capital and the initial shareholding. And then let me proceed. The statement of guarantees provided, the statement of the proposed office, and the statement of particulars of the beneficial owners. This was an amendment that a company must have a beneficial owner when you're applying for registration, the details of the beneficial owner to be included. Is there anything else I need to add?
Well done. We can proceed to BRS. A confirmation from the members. Do we need to see particular application on BRS, or can we just use the practice notes? As we see the practice notes, do we need to see what's on eCitizen exactly? How do you make the applications and such?
Ringera,
Yes.
I am thinking we can just see the applications on BRS.
Yes.
because I am thinking maybe considering the fact that nowadays CLE wants to see procedure mostly,
Okay.
wanaweza test maybe the process of registering a company vitu kaa hizo, so we can just see.
Okay. So I'll present my eCitizen account. So for you to register a company, you first have to have an account on eCitizen. BRS went online. Although the physical registry is still there, the applications are made online. The physical registry is only one in Kenya. It is at 316 Upper Hill Chambers, just opposite Kenya National Library Service. So I'll present this. So on my account, I have a private company that is registered, but we shall just try to do applications for a company limited by guarantee very fast. Then we do application for public company. So you have 5 registries here. When you get into BRS, there are 5 registries. For this particular session, we are only doing company registry. For official receiver in insolvency, that's a different registry. There is the collateral MPSR registry. There's the hire purchase registry, person to the Hire Purchase Act. And then you have the organizations. Now, this is a new one. This is a new registry wameweka juzi. You see this BRS portal, they launched it last year, September. So it has also been a bit of try and error because now they are trying to marry the technology with the statute. They are trying to get what is in the statute to reflect in the technology they are developing. So we in the company registry service, we shall see first a private limited company. So we have one that is registered here. Private limited company. So the first thing you usually give proposed names, 3 proposed names. So we shall go back to make a fresh application and then we see. Then when you give 3 proposed names, they select one name that is not already on the roll of companies, the registrar of companies. They ask you to give the applicant's details, the name, their postal address, very important, and the capacity in which you are making this application. Whether you will participate in the company and such. Then they ask you a question on articles of association. There are 3 options. Either you adopt model articles of association, the ones that are in the Companies Act. You adopt your own articles of association, or you adopt a modification or a customization of your own articles of association and the model articles of association. The issue is, and this is where the advocates come in. If you decide to either adopt a customized article association where it is your own and the model together, or where you choose to adopt entirely your own, then you must ensure that the clauses in these customized articles of association, they reflect actually what is in the model articles of association, and they may be rejected if they are too wild. Because there are some things you can enter into that article association and then we can say this is too wild, you have gone out of the topic. Then objects, if any, for which company is regulated, established. This one is to establish whether you are regulated or non-regulated. Regulated means basically you're handling money. You're handling financial services. If your company or a business is handling financial services, it means you are regulated. But if it means that you're just a conventional business, it is just non-regulated. So they ask you primary objects of the company. This primary object is, you see, when you form in your company, we mention memorandum of association and articles of association. So something about the memorandum of association. The first thing that a memorandum of association will state, and I hope I can present one later, together with an article of association, I will present. One thing it will state, it is the primary objects of the company. So for example, if I am a company, so for the example, this one is a company that is website to do business in the in marketing. Then the other thing it should state is the subscription. You see, the memorandum of association. Now, not here specifically on BRS, but the memorandum of association should also state your subscription. And who is a subscriber? A subscriber is someone who wishes to buy shares in the company with their money. So, for example, we just go and take in the world, we say we're going to name this company at 20 shillings per share. Then we choose to have 1,000 shares. So when you multiply 1,000 by 20, that gives you 200,000 Kenya shillings nominal capital. But there are three ways in which you can subscribe to a company. So the subscribers can wish to subscribe at a discount. So if the shares are being bought at 20 shillings, we say, no, that is too expensive. You're going to buy this company at 10 shillings first. So it means that there's an unpaid amount, you see, of 10 shillings, as Chadwick was stating about paid and unpaid terms. Then you can purchase shares at their nominal par value. Par value, PAR. The word is PAR, par value. The nominal par value means you bought the shares at that specific 20 shillings. So we said we have 1,000 shares and we are buying them at 20 shillings. We just buy the whole thing, and the nominal share capital of the company, 200,000, is deposited into the company. Then there is the third way of subscribing is at premium. So, for example, we have just stated that we for us to mitigate expenses and costs, we say that because we do not want to exceed the 5 million cap, because there is a 5 million cap. So if your company is worth more than 5 million nominal capital, it means you have to register for VAT, value added tax. It means you have to register for, you have to pay stamp duty at registration of the company. But if your company is less than 5 million shillings nominal capital, it means you are exempted from stamp duty. We shall see what the exemption looks like. It means you are not liable to register for VAT, not unless now you're in business, not unless now you're doing business in terms of the type of business now must be registered for VAT. You see, it's not all companies that register for VAT. So we shall also see that which companies are. So that's another session, because that session is in the tax procedures. The tax procedures that are coming in that term. Now here in the session here, how do you choose the nominal capital? What are the mitigations you can do so that you navigate the tax procedures? No. That's why tax procedures are very important in commercial transactions, because you're forming a company, but you're getting into business. And then when you have to answer to the taxman, you have to answer to Caesar. Then that's tax procedures. We'll do that one later. So let's proceed. You say maybe your primary business activity, your division, group, class, target business start date, and then accounting period and month. So this means that your accounting shall be done on this day. So this is the same date that registers with KRA as they are giving a KRA pin for the company. So for example, for this one, it will be 31st December every year. Then your estimated annual turnover. If it is over 500, if it is over 5 million, then you have to have a company secretary. And also, if your nominal capital is over 5 million, you have to have a company secretary. Is the company you're registering a subsidiary or a subsidiary company or a branch? No. Was it formed of amalgamation or acquisition? Or you see, now this is where M&A joint ventures come in. Then that's the first details. Then you go to the registered address, you give them an address. Very important is the company email address and the company phone number. So those ones are very important. Then you just give a physical address, your registered office. Then a nominal capital, for this one you can see they went with 1 shilling for 100,000 shares. Then the ownership details, you enter who are the shareholders, you enter their, so this part of ID, the auto system generated, we shall see. You give them you upload a passport photo that can be viewed actually. You just give them a passport photo. Then you see, then you give them your residential address as a subscriber to the company, as a promoter. Then you say what percentage is this person holding. and then you issue the shares. And then when you say issued, it means that they are paid up. You see, if you say you've issued all the percentage that you have issued them, that they will hold, it means that they are paid up. So, for example, it could be the issued is 26,000, but the paid up is, let's say, 20,000. So there is 6,000 unpaid. Then there is something about beneficial ownership. Chadwick mentioned it on Section 16A of the Companies Act. It is also mentioned in Section 93 of the Companies Act. We shall see in the companies forms. We shall see what is beneficial ownership. We shall also see the beneficial ownership regulations. It's just a short document. We shall also see it. Then that's it. Basically, that's it. So are you going to add a secretary? No, because it's not a must for you, because now for this company, it's not over 5 million nominal capital. Then these are the application documents. Then we have Form BOF1. Now this is the Form BOF1. This Form BOF1 is the form that that captures who is the ultimate beneficial owner. It is pursuant to Section 93 of the Companies Act. It's a very important one. There are so many past papers about this particular thing. So I would wish Chadwick to read again Section 16A and Section 93A before we proceed very fast. Then we shall see the beneficial ownership regulations later as we conclude on the whole ownership, beneficial ownership. And also for limited liability partnerships, there is the question of beneficial ownership. So we shall also see that. Chadwick, if you can locate Section 16A and Section 93A of the Companies Act.
Yes, I'm on it. Let me just read it. Section 16A, Statement of Particulars of the Beneficial Owners. 16A1, the applicant for registration shall ensure that the requisite statement of particulars of the company's beneficial owners complies with subsection 2. Subsection 2, the statement of particulars of beneficial owner shall contain A, the required particulars of anyone who is a beneficial owner, and any other matter that, on incorporation, shall be required to be entered in the company's register of beneficial owners under this Act. If I proceed to Section 93, Section 93A. Okay, it says a company to keep register of beneficial owners. 93A1, every company shall keep a register of its beneficial owners. 2, a company shall enter in its register of beneficial owners information relating to its beneficial owners as prescribed in the regulation. 3, a company shall lodge with the registrar a company of its register of beneficial owners. 3, subsection 3A, in case of a proposed company, when submitting documents as provided under section 13 of this Act, and B, in case of existing companies within 60 days of coming into force of this section. So you have to lodge with the registrar a copy of the beneficial owner's detail. And then subsection 4, the registrar may, on the application of the company or of any other reason, the registrar think fit, extend the period referred in subsection 3B for a period not exceeding 30 days. 5, a company other than a public listed company shall lodge with the registrar a copy of any amendment to its register of beneficial owners within 14 days after making the amendment. So you're also allowed to amend the particulars. And then 6, notwithstanding the provision of subsection 5, a public listed company shall lodge with the registrar a copy of any amendment to its register of beneficial owners within 30 days after making the amendment. 7, every company shall keep records of its beneficial owners' information for at least 10 years from the date which a person ceases to be a beneficial owner. If a company fails to comply with the requirements of subsection 5, in subsection 6, the company and other officer of the company in default is liable to pay the registrar an administrative penalty of 2,000 shillings. If the company continues to fail to comply with the requirements of subsection 8, the company and each officer of the company in default is liable to pay to the registrar a further administrative penalty of 100 shillings for each day of default. 10. If the company does not comply with subsection 3b, the company and each officer of the company who is in default commit an offence and on conviction are each liable to a fine not exceeding 500,000 shillings. Subsection 11. If after a company or any of its officer is convicted of an offence under subsection 10, the company continues to fail to comply with the relevant requirement, the company and each officer of the company who is in default commit a further offence on each day on which the failure continues, and on conviction are each liable to a fine not exceeding 15,000 shillings for each such offence. Subsection 12. Notwithstanding the provision of subsection 10 and 11, the registrar may give a direction to a company that is in breach of subsection 3b, specifying a. the statutory requirement for which the company is in breach, b. the action that the company is required to take, c. that the company has to comply with the directions within 14 days, and d. the consequence provided for under section 894 for failure to comply with the directions by the registrar. So this company act, it actually refer you to the sections that are previous and also that are current and also before. What do I mean? Like you see in subsection 12, you see it's refers to subsection 894 as well. So in your free time, even as you're reading, you also go and peruse the sections that are quoted. Or maybe, can I also read that, Brian? The subsection.
Yes, read it 94. It's a
Okay.
good one. Link it
Okay.
on your returns. Let's see.
Let me read it. Let's read it shortly. Okay, so 894 talks about the power of the registrars to strike off a company not carrying on business or in operation. So it's quite long. There's 7 subsections, but let me just try to read it. So 84.1, if the registrar reasonably believes that a company is not carrying on business or is not in operation, the registrar may send to the company by post a letter inquiring whether the company is carrying on business or is in operation. Subsection 1A, for purpose of subsection 1, grounds upon which registrar may form a reasonable belief that a company is not carrying on business may include where a company has failed to file annual returns or financial statement for a period of 5 years or more, or where a company has failed to comply with the requirements to lodge a copy of the register of beneficial ownership after being issued with a directive under section 93A. So the cabinet may make regulations specifying the grounds upon which a company may be considered to be carrying on business for purpose of this section. Subsection 2, if the registrar does not within 1 month after sending the letter receive any answer to it, the registrar shall within 14 days after the end of that month send the company by post a registered letter referring to the first letter and stating that no answer it has been received to it, and b, if no answer is received to the second letter within 1 month after its date, a notice shall be published in the Gazette with a view to strike the name of the company of the register.
Yes. Hello, Mr. Cheduk.
Yes.
For the purposes of the discussion we were having, we shall hold it there because the following parts of that section 894 are talking about strike off. And for the purposes of this discussion, there's that part you've read about whether the company was filing annual returns for the last 5 years. And that's why I wanted you to read section 894, subsection 1 or thereabout. So now, for us to come back to section 93, why is beneficial ownership so important? What is the rationale? We have read section 93, we have read section 16A. I implore you to go and read the beneficial ownership regulations. I think that document is 5 pages. Kindly just go and brush through it. You shall see everything. But I want to ask a very specific question. What is the rationale of having beneficial ownership? And why was beneficial ownership stressed in the Companies Act 2015, whereas it was not stressed before? in the Cap 486, yani before 2015. Good one. Someone said money laundering. Yes, tick. The first that was the first risks that they were mitigating, and now the rationale now itself. The rationale now, as per the law and now the legislation or the legislative intent, kindly someone to now expound on how did money laundering push the legislation of beneficial ownership in the Act and the addition of Section 93A in the Companies Act 2015, because it was not there, and 16A and beneficial ownership regulations. I think they're in 2021. They're done in 2021. No, not 2021. Around 2017. Regulations are for 2017. Someone to expound? So let me go so that we can proceed. So the rationale is this: lifting of the veil of incorporation. So you can before 2015, you could have had a company where, so for example, if our nominal value is 1 shilling, then we have 100,000 shares. You could have found that if there are 3 directors, each of the 3 directors wamechukua only 1 share, 1 share, 1 share, which is to say that there are 99,997 shares that are held in the wind. They are held in Comunicado. They are held at Transa. And what are we trying to say? This is where the issue of even paying up came in, because you shall have kila mtu amechukua 1 share, si ndio? But ikifika the day of winding up of the company or liquidation, or the company to answer to its creditors, or the company to answer for dividends and profits, ulikuwa unapata there were complications, because if mmechukua 1 share, then why are you entitled to a third of the company? Unaona? So the business registration service, post 2015, now the register of companies, they came up with this to ensure that they know who is the ultimate beneficial owner. And by ultimate, we mean that we shall know to the last share. Let me now give you now the full rationale again. For example, you have corporate shareholders. So you have a company where you say, let's change it. You have 1 shilling per share, then you have 100 shares here. Then 60 shares are already taken by individual shareholders, but there is 40 shares that is held by XYZ Limited. Then we need to also know who are the owners of XYZ Limited. So if XYZ Limited owns 40% of ABC Limited, then we need to go to XYZ Limited to see who is the owner of the 100%. So that when you go into XYZ Limited, you might find that XYZ Limited is owned 50% by EGH Limited and MNO Limited. So you have to go again into MNO and EGH, you see who is the owner of the 100%. So the cycle of beneficial ownership is investigated through a company search, an official company search. And one thing you have to know, that company searches are public documents. Let me share company search very fast, then we go back to now what was our presentation. A company search, and why we are saying it's a public document. So for example, let's see very fast a company search. We see why it's very important, why it tells us who are beneficial owners, why the banks they always want a company search. I'll present one yes very fast, because these are public documents, so there's no conflict Damn.
Hello, Brian. Are you sharing something? Because you can see the Companies Act 2015.
Hello.
Yes, I'm
Are
saying,
we-
are you
yes.
trying to share something? We can see the Companies Act 2015.
Yes. No, this is a company search. Yes, this is a company search. So a company, official company search, this is what it looks like. So anyone in the world. So for example, anyone in the world. Anyone in the world. So when I say anyone in the world, as long as you have an eCitizen account, so you can register. For example, if it's someone from wherever, they can just come with an email address and their password. They register for a foreign account using their passport number. They get an eCitizen account. They go and search your company. They will get all this information. This is public information. You just have to pay 600 shillings to see any company in the world. So, for example, if we want to see Safaricom right now, we just pay 600 shillings. We see who are the owners of Safaricom moja moja. We want to see the owners of which company, we just go pay 600 shillings, we see. This is public information. So it captures company name, type of company number, nominal share capital, date of registration, office, postal address, encumbrances section, debentures, charges, and such. Then the name of the directors and shareholders, their addresses, their description, and whether there is a secretary. That is what an official company search is. Formerly, it was called a CR12. So you might have heard of the term CR12, but nowadays it's just called an official search. Then we go back to BRS. So if there's any question on that, so that we proceed now with BOF. So we have read BOF. We know what beneficial ownership is. We have seen section 93A. We have seen how to locate beneficial ownership. How do you search for beneficial ownership? You look for the company search. So that if you find that there is a corporate shareholder, you look for the company search for that corporate shareholder until you get to an individual person. Because an ultimate beneficial owner, and let's stress this, a beneficial owner must be a natural person. Must be a natural person. So that is the rationale for having a beneficial ownership regulations and such. The introduction in the Companies Act. I was presenting a screen here. Let me go back. So beneficial ownership collects the same information, addresses and such. Very important is the email address and phone number, because BRS usually sends notification to that phone number. Also captures the percentage of share, percentage of voting. Shareholding and voting, they are two different things. Shareholding goes to beneficial ownership. Voting goes to running of the business. Then again, the authority of the person, whether they are a director, they can remove a director, whether they have Apologies, I had lost internet for a minute there. So we were going back to the private companies. The other thing is for public companies, so I had misdirected you. You cannot see who is the owner of Safaricom, because for that one you have to apply to the Central Depository and Settlement Corporation, CDSC, because it's a listed company. So you cannot see that one on BRS. You can't see Safaricom on BRS because it's a public limited company, a listed public limited company. So that's another part. Hiyo ni kuhusu financial markets and specialized institutions, but I did not find it in our course outline. So far, so good. So I'd like to present the next form. My internet is a bit slow. Okay, now it is back. So we will see the next forms. So the next form usually fill is form CR1. There are sample forms in the company's registry public pages. So very first we'll see form CR1, we see form CR2, we'll see form so we were at the forms. So we'll see form CR1, CR2, CR8, and statement of nominal capital. CR1. So this is what CR1 looks like. CR1 is the company registration form. It states who are the subscribers to the company. So first director, secretary, and authorized signatories of the company. So by these are the people who have who are the promoters. You see? So the question of promoter comes here. The first directors, these are the promoters. So that's from CR1 basically. Then CR2. From CR2 is pursuant to section 13 of the Companies Act. We saw section 13 of the Companies Act is the memorandum for a company with share capital. It's a memorandum of association. Each subscriber to this memorandum of association wishes to form a company under the Companies Act 2015 and agrees to become a member of the company and take at least one share. At least one share. So for you to subscribe to a memorandum of association, you have to subscribe to the shareholding. That's a must. Then we see that is from CR2. Then we see from CR8. This is pursuant to section 138 of the Companies Act. It's about addresses. The register of companies has to know what are the addresses of each director, residential or otherwise, or a business address. you have to give an address. So you give notice in accordance with Section 138 of the Companies Act that in relation to a director of the company listed in column 1 of the following table, the director's residential address has changed to the address specified opposite the director's name in the column 2 of that table. So basically, that one collects information on addresses pursuant to Section 138. Please go and see. Then this is where we were talking about, we shall come to see about stamp duty. In what instance can you be exempted from paying stamp duty? So, statement of nominal capital, it is pursuant to the Stamp Duty Act, Section 39, and the schedule, Article 8 of the schedule. So, this statement is to be filled with a memorandum of association or other document when the company is registered. So, the nominal capital of this company is 100,000 divided into 100,000 ordinary shares of 1 shilling each. Then there is the exemption because the nominal capital does not exist, 5 million Kenya shillings. That's the reason why this company is exempted. Otherwise, you would have paid stamp duty in the number of 1%, which is the standard. Then from there, we wish to present a BRS notes very quickly, a recap of incorporation of companies. Before I get to that, I've remembered we had said we shall see registration of other companies. So you come here, make application on BRS. So there's registration of a business name. This is the sole proprietorship. Registration of a company limited by guarantee. You can do a specimen application. You just don't have to submit it. You can do a full application, download all these forms and see them. It's allowed. You can do that, then you can delete the application later. Then registration of limited liability partnerships, registration of a public limited company, registration. This one is charges. Charges are restricted to advocates and insolvency practitioners. You see. Then registration of a foreign company, registration of a private limited company, the one that we have just seen, and then there's registration of a limited partnership. Please, when you have time, click any of these applications, go and complete it to the end. So for example, if you click this one, it asks for information. Kindly note, a company limited by guarantees are not for profit. The proposed names, you begin here. So for example, if I enter a name that's already in the roll of companies, it will tell me immediately that it is on the roll. So if I enter such a name, let it compute. So it says the name may not be available because it's similar to some other names. Well wishes, let me call this company limited by guarantee well wishes. You see, it still says I can't register because there are names that are similar. Ginny the wish granter. So if you enter a name that is not on the roll, it will accept. You see. Then I can also abbreviate, call it a company limited by guarantee, CLG, instead of the whole word. Then I can enter a proposed name, a second one, a third one. Then they ask you whether you wish to dispense. You will pay an additional 3,000 Kenya shillings. So there's a lot of mechanics to it. Then you continue to select articles of association. You continue to enter registered address, ownership information, and application documents. So it is the same for all companies. You can make a specimen application and then you can see that. So I wish to summarize that with these BRS notes on incorporation so that we can proceed with today's session. Let me present now BRS notes. So these BRS practice notes on incorporation. How to incorporate a company? What is incorporation? Incorporation is the process by which new or existing business registers as a company. Business cannot be registered as a company unless it has been incorporated and registered at the Companies Registry under the Companies Act, Cap 486. Please remember that the citation is this, not Companies Act 2015. Who can incorporate a company? A company can be formed by one or more individuals, including corporations and other legal persons, by subscribing their names to a memorandum of association. The memorandum must be signed by the subscribers, incorporators, and lodged electronically, e-citizen, with the registrar. Which types of companies are available? There are 5 types of companies. Private company limited by shares. This type of company has a share capital. Each member's liability is limited to the unpaid amount on their shares. Private company cannot offer its shares for sale to the general public. And also another thing about a private company, it can only have up to 50 members. So that now if your members are 60, then you cannot register a private company limited by shares. A limited company, this type of company has no limit on the liability of its members. Public limited company has a share capital and limits the liability of each member to the amount unpaid on their shares. It may offer its shares for sale to the public and may be listed on the stock exchange. Company limited with guarantee, this type of company does not have share capital. Its members are guarantors, not shareholders. The liability of members is limited to the amount they agree to contribute to the company's assets if it ever dissolved or wound up. The amount is usually fixed, nominal sum outlined in the company's memorandum. So for this one, for company limited by guarantee, they form the memorandum form, which is form CR2. Now for this one, the form CR2 of this one usually lists, in case of the company ever dissolved or wound up, how much are you willing to contribute? So for example, if you're opening a company limited by guarantee for a hospital, and they say, we are 6 members, so each of us will contribute 6 million as a guarantee. So how much is that? 36 million as the guarantee amount. But this amount is not a must be paid at the point of incorporation. It can remain on book. But the day you wish to wind up the company, you must have that amount on hand, because you promised, you pledged to contribute 6 million, each of us, the 6 of us, to form a company. So foreign companies, this type of company is a branch of the company registered out of Kenya, has established a place of business in Kenya. You will see practice notes number 7 for foreign companies. It's quite lengthy, and it is CLE tested. Foreign companies is CLE tested. So I wish we see that these specific parts when we're doing past papers, we were just doing a refresher. What documents are required to incorporate a company? To incorporate, you need to submit the following documents electronically. Section from CR1, we have seen it. These are the promoters. Section from CR2, memorandum of association for companies limited by shares. From CR3, memorandum of association for companies limited by guarantee. So for companies limited by guarantee, this is where we enter that 6 million. We come and say these are the 6 members who have agreed to subscribe. And then in case the company is ever wound up, in case the company is ever under administration, in case the company is ever under liquidation, each of us will contribute the amount we pledged. So you don't have to pay the amount now for companies limited by guarantee. At incorporation, no. You can just begin your operations, you can go do your charity work. But if the creditors ever come calling or such a scenario, or if the point is home, from CR8, registered residential address of the directors. CR10, if you are appointing a secretary, it is optional for some private companies. Which companies are these? That it is optional. For you, it is obligated or mandatory for a company to have a company secretary if your nominal share capital exceeds 5 million Kenya shillings. Why is that the cap? Because that is the cap because for a company that has 5 million nominal capital, then it means you are not exempted from paying stamp duty at the point of incorporation, you see, on those shares. For the members to subscribe to those shares, the company must pay stamp duty on those shares. You see, those shares are not exempt because they are exceeding 5 million, and that's the reason you need a company secretary. Form CR12 is the residential address of the company secretary. Again, this point says optional. It's optional because it's optional for company to have a company secretary if they are memorandum of association subscribed less than 5 million Kenya shillings. Articles of association, optional if model articles are adopted. And we said if you are adopting your own, you have to have an advocate to write them for you, because then if you write your own, they have to comply with these model articles, the specific clauses that are there in the model article. So it's a whole thing. Then the statement of nominal capital, this is where you say that our nominal capital is this amount. So if it is exceeding 5 million, we pay stamp duty on it, and we have a company secretary. If it doesn't, we just develop it. We just register the company without a company secretary, without paying any stamp duty on the registration. Then Form BOF1, we have stressed it enough. Then you lodge this on eCitizen, you download forms, you signature, you scan, then you upload the documents. Then you make sure all information is accurate. Then you'll be given an output of the name reservation certificate, a statement of official search as at that date, certificate of incorporation. So in practice, an official search is only valid up to 3 months, because anything could have been changed in that company within the 3 months. So for example, for this one that we had here, let me share it very fast. Let me share very fast those 3 documents you have seen there. So these 3 documents, this is what we have seen in that practice notes. So the first one is a name reservation certificate. So the Register of Companies reserves the name for you for the next 30 days so that you may proceed with the incorporation of the company. This to allow you to protect this name until you register, or if your application is ever rejected or something. But basically, they just want you to reserve so that there's no conflict now. Somebody else has applied with the same name. You see, everything now is electronic, and anyone could be registering anything out there. Then that's the name reservation certificate. I don't think I've shared it. Oh, yes, I did not share. Let me share. Yes, this is the name reservation certificate. Says that you have that the Register of Companies writes you a letter, tells you we acknowledge reservation of the following names for a private limited company. Note that there are types of who are the agents who can apply for this. You can either be a director, you can be an advocate of the High Court of Kenya, you can be a company secretary, a certified public secretary, registered with the Institute of Certified Public Secretaries, established in 2001 or something, or in 19 something. Okay, we shall see how they operate. Then there's a certificate of incorporation. This is issued by the Register of Companies. It's a system generated certificate. Then we have the statement of official search. So you can see for this search, it is Wednesday, 15th October 2025. So for example, if I was taking this to a bank and I want to open a bank account, they will tell me go to eCitizen, pay for 600, generate a search that is a current date. Because you might have changed anything in this company in the last whatever months, in the last 10 months. So you might have changed the registered office, you might have already sold some shares, you might have new shareholders or something. So that's why a statement of official search is only valid up to 3 months. And in some instances, like Safaricom, they usually request one that is valid on the same day. So if you're making an application, for example, for a pay bill, ya your company ama a phone number. Safaricom anakuambia generate one today. Safaricom wataki hiyo jokes, wanataka kuiona ya leo. So that's something else. So we go back to our practice notes. I want to complete this very fast. I took you the registration of a private company limited by shares, because the moment you do private company limited by shares, then that means all these others are variations of the same. I don't want to call them variations, but basically they are variations of private company limited by shares. You see, when the Englishman was developing these things, the first thing he came up with was the private company limited by shares. Then all these variations have been brought by common law and practice over the centuries. So we were maybe looking at these practice notes, and we were here. So beneficial ownership, we saw it. A beneficial owner, any individual, natural person who ultimately owns or has significant influence or control over the entity and stands to gain financially from its operations, even if they do not appear on official documentation as shareholders or director. It can be direct shareholders, indirect shareholders, a person with voting control, significant influence, person, a trustee, settler, or beneficiary of a trust. So there's that part of declaration of trust and such. I think it is in the course outline, but we shall see it later. You must register any beneficial owner that meets one of the following conditions, known as the natures of control. A beneficial owner is a person who holds directly or indirectly more than 10% of the shares and in the entity, holds directly or indirectly more than 10% of the voting rights in the entity, holds the right directly or indirectly to appoint or remove a majority of the board of directors of the entity, has the right to exercise or exercises significant influence or control over the entity. Users should refer to the guide to beneficial ownership disclosure issued and available on BRS website. This is issued pursuant to the Beneficial Ownership Regulations 2017. The following documents are required for each director: foreign residents and shareholders, a copy of Kenya National Identity Card, foreign resident, a copy of Kenya Foreign Certificate, au ni alien, ile yenye inaitwa alien card. Foreigners, a duly notarized of a copy of a valid passport biodata page. You can get it notarized at the embassy of the specific country. Local company, a copy of certificate of incorporation. For foreign company, a duly notarized certificate of incorporation, notarized from the company of registration. This is a very, very important part. I was registering a company, foreign company, so near Uganda. You are registering here in Kenya. And they had notarized it kwa embassy ya UG. So jamaa alienda toka notarized. It was rejected. It has to be from the company of registration. It is different from a passport. Passport unaweza enda notarize hapo kwa embassy. But for this one, they might accept it, but they might also reject it. I don't know why. BRS is not an exact science that this is this, no. A passport sized photograph for individuals, occupation of individuals, email address, telephone number, postal address, business address, and residential address. You choose a company name. We saw you enter your names. Then it tells you whether the name is identical or something. So we shall proceed very fast. You consider the following points. So this is also specified by the Companies Act on the naming. Ukienda kwa schedule ya Companies Act, there are specific guidelines on naming of a company. So I hope you shall look at it. The company name may not contain more than 160 characters. The name of a limited company that is a private company must end with either limited in full or LTD. The name of a limited company that is a public company must end with PLC or public limited company. The name of a company limited by guarantee must end with limited or LTD, but applicants seek an exemption from using these are typing error. Let's read it again. The name of a company limited by guarantee must end with company limited by guarantee or CLG. We saw that. So hapa ni typing error. If walikuwa nafaa weke hapa either company limited by guarantee in full or LTD or sorry, not LTD but CLG. Hapa hii ni typing error wakiweka hapa. but applicants must seek an exemption from using CLG, your suffix CLG or company led by guarantee by paying 3,000 bob. Offensive or abusive words are not allowed, including in vernacular languages, mother tongue. So kumbuka BRS, I want to tell you something about BRS. Offices za BRS ziko 360 in Upper Hill Chambers. And that's where the headquarters ya NIS iko, uko the headquarters ya the whole government, 360 in Upper Hill. So they have all the intelligence. So if you are trying to register a company and then you give us the name in, for example, which is a language that is registered in Kenya. So for example, the ethnic. So we can have you're giving us a name in Kikuyu or Kimeru or in some other language, Masai, and it is an offensive word. They will note it and they will tell you for corrections. Political names are not allowed. You can't generate a name that looks political. No. You can't generate a name like, for example, you can't call your company, we shall see it in a bit. You can't call your company Government Affairs Limited, no. You see, that's a reserved name. So there are these rules. There are a lot of rules on naming. The name should not be the same as or similar to that of a registered trademark. It may therefore be important to also conduct a search on the trademarks registry. So you can't register a company where that name has already been registered as a trademark by someone. Names containing the words cooperative, society, or trade union are not allowed. Numbers may be used in any part of the name. A full stop, comma, colon, hyphen may be used. Punctuation marks, these ones may be used. Signs, symbols, if they are not may be used only if they are not one of the very first letters of the company name. So you can't start with hashtag, then the name now. The name should not start with the words Kenya, as the same is reserved for government-owned entities. So I find this to be a rule that is not followed. There's a company named Kenya Produce Agency, and it is a private company. So BRS is also not an exact science. Some of these rules unaona zimekuwa generated 2015, but hiyo company yenye mimi najua inaitwa Kenya Produce Agency, that company was registered in 1932. It was registered when Kenya is still a colony. I saw the certificate of registration. It is certified by the Protectorate, by the Queen Protectorate Colony of Kenya. Sijui kwa hapo na logo ya Queen, si logo ya coat of arms ya Kenya, hapana. Logo ya Queen, huyo Queen ya England, 1932. So these rules, they cannot be applied now to companies that were already registered. That's what I meant. Unaona? That's what I meant. So that company, unaweza enda tu kwa BRS. Just search, acha nikuonyeshe. Let me show you that company. It's public information, as I told you. Anything about companies is public information. I can just come here, search a company. So I've called Kenya Produce Agency. It's a private company, and they're telling us you cannot register a private company with those names at it because it's reserved for government. Unaona, hizi zote hizi Kenya Produce Brokers, Kenya what. So unapata ni their businesses owned by individuals, but it's because they were registered before 2015, and that's why these names bado wanaziona. But now after 2015 you can't enter the name Kenya in any company. So basically you get the idea. Let me proceed. The reservation of a name of a company is at the discretion of the registrar. So it's the registrar to reserve the name for you. It's not you to prescribe to the registrar. The incorporation fee is 10,750, or as tutorially prescribed, currently takes 1 to 3 days to incorporate a company. True, by the way, they are very quick about registering companies. Articles of association, members can determine to prepare the articles of association. They can also adopt model articles of association set out in Companies Act, General Regulations 2015. So I told you there are so many regulations passed on to the Companies Act. We shall maybe be able to see them when we are doing past papers. You're not obliged to adopt provisions of model articles, but they are suitable for standard companies to govern the internal management of the company. Standard companies means kuna ile kampuni yenye you see that these companies like holding companies, for example, you're developing a company just for holding shares in a real estate, unaona. So you don't need to have a lot of rules. But if you're developing a standard company, unaona, a company whose members need a lot of governing, you see, then you do your own articles. There are different prescribed model articles for private companies limited by shares, private companies limited by guarantee, public companies. You may find the models in here. When you complete the online application, you need to specify whether proposed is adopting model articles in their entirety. Applicant is required to tick the box. Company will adopt model articles. Model articles with amendments should be attached to the application. They should be duly signed by all the subscribers. Bespoke articles that it has prepared for itself. Copy of articles should be duly signed by all the subscribers. There are no model articles for limited companies, but an limited company can adopt model articles for limited companies as the basis for its articles. The articles for association for an unlimited company must not include provision for liability of members to be limited. It is advisable to obtain professional legal advice if you are thinking of incorporating an unlimited company. Actually, this disclaimer here is very important. Unlimited companies are tricky. They are tricky. You know, if it is unlimited, it is unlimited. So, for example, if our creditors come calling and we had a company with a nominal share capital of 1 million Kenya shillings, and our creditors are coming calling for 2 million Kenya shillings, we can only pay the 1 million that our liability is limited to. But for an unlimited company, if they are coming calling for 2 million Kenya shillings, then you pay them 2 million Kenya shillings because your liability is unlimited. Where can I obtain articles of association which are appropriate for company? What is the registered office? How many shareholders? This is very important. A private company must have at least one and not more than 50 members. So you can have a one-man company, but your members cannot exceed 50. Shareholders who are former current members of the ESOP are not included in the maximum restriction for private companies. So, for example, you're developing a technology company, and then the technology company will develop mkambiana that the remuneration is sweat and blood. So it is for the developers who develop the system then runs a business. So if the shares in uliwapea for their sweat in developing that website, then it's not counted in the limit of 50 members for a company. Then there is a minimum requirement for one shareholder member, no upper limit on the number of members that a company limited by guarantee or a public company may have. There's no upper limit. The minimum is one for either CLG or a public, but there's no upper limit. You can have 1,000 people. How many directors can a company have? A private company or a company limited by guarantee must have one director, while a public company must have at least 2 directors. These are must. At least one company, a director must be a natural person. All directors who are natural persons must be at least 18 years old for you to have capacity. Where a company with a guarantee adopts model articles, they shall be required to have at least 2 directors, must have a company secretary, it will mention. Private companies with a paid up share capital of less than 5 million or a company limited by guarantee are not required to have a company secretary. However, all public companies must have a company secretary. Local companies with all foreign directors must appoint a local contact person, a company secretary, or an advocate. So you remember this where it says that the persons who are advocates before 202, they were automatically company secretaries. But for you to become a company secretary in Kenya right now, you have to do exams with CASNEB, company secretary exams. There are 16 exams and a project. So then you apply to the institute to be named a company secretary, wanakupea stamp. So these people want to operate the one unit ya commercial peke yake. Then advocates are allowed to operate in the 9 areas of practice. But for company secretary, it's just that single area of practice, commercial, ATP 108. The company secretary must be qualified under the Certified Public Secretaries Act of Kenya. Then certificate of incorporation, it is proof the company has been properly registered, it confirms all requirements have been met, contains details, company name and registration number, date of incorporation, type of the company, company status, verifiable code, how much does it cost, 10750 for private companies, public companies. Then for CLG, if you wish to dispense with the word CLG, you add 3K. Yes, and we are there. We are done with, let me see if we are done with the refresher, because I wanted to cover all these incorporation. We have done memorandum and articles of association. I find we are done with the refresher, because now it's better if we did past papers, so that now we get to deep understanding of how companies operate, and then we would even be able to move faster. So members, are you there? I find that we have done a good refresher. Any questions before we begin the question papers? Any question? I would like us to do question papers. When we see the question papers, then it will assist us to